Hey there, guys. I always find the law on duress to be really interesting because, from a common sense point of view, it's completely understandable to have a situation where, if, say, someone threatened you with a gun if you didn't steal something from a store, then you ought to have a defense to that. But from a technical or a legal point of view, it's interesting because you've committed the offence. You've got the full actus reus, the full mens rea, and yet the law is saying that you're not culpable for that crime. So we're going to have a look at that today. Fortunately, there was a really good case in 2005 called Hasan that basically sets out the law on duress in 7 relatively easy stages. So let's get started with those steps right away. As I mentioned in the introduction, we're going to focus on the case of Hasan from 2005 and, in particular, Lord Bingham's judgment, where he sets out 7 key steps for identifying duress. So we're going to go through each of those 7 steps in turn, and once we've done that, we'll have a good idea for approaching a problem question on duress or even an essay question through academic criticism of the law in this area. So the first step is a threat of death or serious injury. So unlike the American system where the threat has to be proportional to the crime being committed, in the UK there's very much a minimum standard of a threat of death or serious injury before the defence of duress can actually be raised. So this has been given quite a strict interpretation by the courts. In Akins, the defendant was threatened to be punched in the face if he didn't do what he was told, and that wasn't considered to be death or serious injury. Quayle is a really interesting case. It's to do with a person who was growing cannabis. They tried to raise the defence of duress on the basis that they had multiple sclerosis, and so if they didn't take the cannabis, then that would be serious injury to themselves. And the courts kind of got around this, probably more on policy lines than anything else, by saying it would cause harm but not serious injury. So an interesting case that we'll come back to and have a look at later on in this lecture as well. The threat has to be extraneous. In Roger and Rose, a prisoner found out that his sentence had been extended. He thought he was going to commit suicide if he didn't manage to get out of the prison, so he broke out, was obviously rearrested and charged with breaking out of prison. And because the threat was only within himself, so he was threatening himself with suicide essentially, that defence was not allowed to stand there. Also, the threat need not exist in fact. Now, Safi is a case where a person thought that they were under threat from the Taliban, and it was questionable whether them or their family really were under threat. And that was questioned at the court. However, the Court of Appeal turned this over and said that the threat doesn't have to actually exist in reality. It's only sort of in the defendant's mind to an extent. So to give you a more clear example, if someone pointed a gun at you and told you to rob the local corner shop, then you would do that. But if it later transpired that the gun wasn't loaded, it would be unfair to not allow you the defence of duress, because how would you know whether the gun is loaded or not without pushing the perpetrator? So secondly, the threat has to be against either the defendant himself or someone close to him. Again, we can go back to Lord Bingham in Hasan here for 2005. He kind of sets out the relevant people. So we've got the defendant themselves, immediate family, someone close to him possibly as well, or someone for whom he is responsible. And I've put there at the bottom of the slide that someone for whom he is responsible is perhaps deserving of a broad interpretation by the courts. There's not been too many cases that have looked at this closely since 2005, but you can imagine a situation where, say, someone is threatening a bank clerk with a gun, or threatening, say, a customer with a gun and telling the bank clerk to open the safe or they will blow the customer's head off. Now, it would seem unfair to deny the bank clerk in that situation the defence of duress simply because they don't know the customer who is having the gun pointed at their head. So we can argue, if you could argue that the bank clerk is essentially responsible for the life of the customer at that particular stage, then I think that that would be a fair interpretation of the law. But as I've said, this hasn't really been put to the test. The third step is a reasonable response to the threat. So the criminal conduct has to be objectively a reasonable response to the threat of death or serious injury that's been issued. And I've put a really good quote there from Lord Holsham in Howe from 1987. Essentially, the defence fails if a person of reasonable firmness, sharing the characteristics of the defendant, would not have given way to the threat. And this really emphasizes the objective nature of the test that we've got here. So there's no subjective elements as such. We're taking a very objective approach of how would the reasonable person respond to the threat? Would the reasonable person commit the crime in response to that particular threat? We can also go for Lord Lane, Lord Chief Justice in Graham. He gives a quote along a very similar lines, sets it out in a sort of two-part test, and you can go and have a look at that online if you want to. But before we move on to the next stage, I do want to have a quick look at the idea of the characteristics, because while it is an objective test, we can also take into account some of the characteristics of the defendant. So this obviously raises the question about, well, which characteristics can we take into account? So I've made a table here. Accepted characteristics would be something like a recognized mental illness or a psychiatric condition. This was the case in Bowen from 1996. However, if we see on the other side of the table, we can also see that the same case argued that simply not being of very high intelligence isn't really enough of an excuse. Essentially, the court put forward the argument that someone with a low IQ may still know right from wrong and still may refuse to do something if they know that something is not morally correct. Age has also been accepted as a characteristic in Ali 1989. However, being emotionally unstable is not enough, and that was seen in Hurst from 1995. There's perhaps a link there between a spectrum between Bowen on the one hand, where mental conditions will be allowed, but simply being emotionally unstable, so not having a registered medical psychiatric condition, will not be allowed. And that was sort of, I think that's where Hurst draws the line essentially. Emery is really interesting, gives the idea of dependent helplessness. This was particularly relevant in cases where there is domestic violence or a partner is particularly dependent on the other person in a relationship and is almost subdued to beneath them. I guess that this could also amount to a psychiatric condition almost, kind of similar to battered wife syndrome perhaps, or something like that. But it raises another really interesting argument that might not otherwise have necessarily fallen under a registered psychiatric condition, especially not in 1992, but perhaps more so now that that's more widely recognised within society. There's a couple that I haven't put on there as well. There's not really any cases for them, but certain physical characteristics would probably be recognised as an essential characteristic as well. So a physical disability, especially if we're already allowing a mental condition to be allowed as a characteristic, then if the physical condition was prescient or relevant to the case, then that would probably be allowed. And this would also probably go so far as to include pregnancy as well. So step 4, we've kind of got to a part where there's two stages. We've got the threat itself and the crime that's been committed by the defendant. And so step 4 is all about having that chain of causation between the threat causing the defendant to commit the crime. And in tort, some of you may have studied that, probably know about the but-for test. And so we can offer a similar formulation here for establishing a relationship, a causal relationship between the threat and the crime. So essentially we're saying, but for the threat, would the defendant have committed the crime? Valderrama Vega is an interesting case from 1985. There were a lot of factors that were in play in this case, and so you'll probably want to go and read the case yourself. But essentially, that's the formulation that we're using and something that you should look at when answering a problem question. There's also a question about it being a nominated crime as well. So in the classic problem question, you'll probably be saying, X held a gun to D's head and said, go and rob this store or I'll blow your brains out. And so we've got a nominated crime. It's robbery, essentially. But what about when a crime isn't nominated? So Cole and Ali are both cases where the defendants owed a lot of money to the person who was giving out the threats. Now, what happened in Cole was that he owed the money, and the person said, get the money. That was all that they said. And so the person went out, Cole went out, robbed a store and tried to use the defense of duress. But they said, well, he hasn't actually nominated a crime in this instance. And it's not really fair for you to use the defense of duress because you could have gone out and got a bank loan or tried to work out a payment plan. He's not been told by the person, go and rob a bank, and so the defense of duress isn't really available. Ali, the situation was slightly different. Again, Ali owed the person money, but the person actually gave them a gun and said, go and get the money from a bank or a building society tomorrow. Ali went out, robbed the bank, was arrested for it, and this time he could use the defense of duress because there was essentially enough nomination of a crime there. It was clear that the person wanted Ali to rob a bank. So the defense could be used in those circumstances. So something to look out for and an interesting variation in the law. Step 5, there has to be no evasive action possible. So initially the argument would be that the threat had to be immediate. So if you don't do this right now, I will blow your brains out. Then the threat is obviously immediate and there's no chance to go to the police or do anything like that to take evasive action. In Abdul-Hussain 1999, it was a really interesting case, and the House of Lords essentially changed the wording slightly. So it didn't have to be an immediate threat, but the threat had to be imminent. So this was a plane hijacking case coming from Iraq. The people felt that their family was under threat of murder in Iraq and wanted to get into the UK, hijacked a plane in order to do so. And they said, well, the threat wasn't immediate, but it was enough of an imminent threat of being killed in Iraq that the defense could be used to justify the hijacking. Now, moving on, as soon as the threat becomes ineffective, the defendant must stop committing the crime. So as soon as you're away from the danger area, essentially, or away from the threat itself, you have to stop. So DPP and Bell from 1992, someone was threatened by people. He was at the pub at the time. He ran out and drove away in his car, but he was over the legal limit. Now the problem was that Bell kept driving. He didn't just get away from the threat, realized that he was drunk and then stop and call the police or call a taxi to get home. Instead, what he did was he carried on driving after the threat had effectively subsided, and so he wasn't allowed the defense in that situation. There's been questions raised as well before we move on about the effectiveness of police protection. So can the police really offer 24-hour witness type protection to people who do go to them? And if people feel that they are threatened, is it going to be enough to actually go to the police? So in Hudson, the defendants both gave false evidence in court because there were members of a gang present in the courtroom. Now they could have spoken out and they could have given true evidence and said, we feel really worried, we want the police protection. But it was questionable about whether the police could guarantee that. And while they were stood on the stand trying to make that decision, it wasn't really fair on them to sort of say, oh, we can definitely trust the police and these people will never come after us. There was essentially an imminent threat there. And so the people probably made a good decision in those circumstances. So they were allowed the defence of duress. Similarly, where a person's wife was threatening to commit suicide if they didn't take their son to work. In that particular case, it was similarly allowed because even though he could have gone to the authorities, the person was still thinking about the wife's threat to commit suicide at the forefront of his mind. Part 6 deals involuntarily subjected to threats. So if you voluntarily join a criminal gang, then you can't use the defence of duress. So Sharp was a gang of armed robbers. Sharp realised that as soon as they were armed robbers, rather than simply going to steal from a local store without the use of weapons, he tried to pull out. They didn't let him and threatened that they would blow his brains out if he didn't go along with them. So he did go along, but they basically said, well, you've joined the gang in the first place. You were already going to commit robbery. You can't use the defence of duress just because they've essentially added guns to the equation. Similarly, in Fitzpatrick joined the IRA. He tried to commit a crime in Northern Ireland, tried to pull out, was threatened, and again, he wasn't allowed to use the defence of duress in those circumstances. So if you voluntarily join a gang, or in the IRA example, a paramilitary organisation, you can't be expected to be allowed to use the defence of duress. Finally, in 7, we've got a few exceptions to particular crimes where duress can't be used. So in treason, we've got the cases of Purdy, where they essentially suggested that perhaps in the cases of treason there were certain exceptions that would be allowed. Although in Steane from 1947, this was kind of reversed again. So the law isn't necessarily clear on this. To be honest with you, there aren't many treason cases that go about anyway. But I think it would probably be fair to say that where it's high treason, you could probably say that duress is no defence at all. But where there's other types of treason, so subverting British rule or something like that, duress would probably be allowed. So we could look at the type of treason. Murder is really interesting. It's never really been allowed for murder. Blackstone's commentaries: a person under duress ought rather to die himself than escape by the murder of an innocent, which is quite powerful phrasing behind this sort of moral sentiment that Blackstone is trying to convey. The law in this area has been criticised quite a lot. If you are writing an essay on this area, might be really interesting to focus on whether murder should be allowed. A lot of law commission reports have suggested that duress should be allowed as a defence to murder, but that might be something that you want to look at. There's plenty of literature that discusses it, and there's a strong argument that it should be allowed. Howe 1987 I've only put in there because it sort of reaffirms the law as it was in the modern era, essentially saying that duress isn't allowed for murder. But maybe you want to sort of go a bit further, dig a little deeper, and the other thing to say before we finish is that it's not a defence to attempted murder, because it's obviously linked. So the successful completion of a crime, the defences shouldn't be any different to the unsuccessful completion of the same crime. And there we have the law on duress. If you are answering this as a problem question, while the 7 steps do take a bit of remembering and getting used to, hopefully you'll be able to sort of follow them in an exam and take each one in turn, relying on the different case law as you go along, trying to think of some of the different sides of the argument, particularly step 3, the reasonable response to the threat and the different characteristics involved. On the other hand, if you are answering this as an essay question, I do think that there's a lot of different things that you can consider. Should duress be allowed as a defence to murder was one example I mentioned towards the end, but there's loads of really interesting cases. The Quayle case I did talk about in the lecture, about growing cannabis to try and relieve the pain of multiple sclerosis, raises really interesting policy issues. There's also an ancient case called McGrauther from about 1764, I believe, where a Scottish lord threatened to burn down his tenants' farms and kill all their cattle if he didn't join them as part of a rebellion against the English. which it was a really interesting legal question as well as a political question. And the judges in the case actually took the opportunity to develop a lot of the law of duress as we actually know it today. So I hope you've enjoyed this video and found it useful. If you did, leave a like. Also subscribe for more videos. This is part of a mini-series on defences in criminal law. And if you have any questions or recommendations for other videos you'd like me to do, then leave those in the comments below. Thanks very much for watching. Bye!